We understand the difficulty that the NCE examinations present, and we help candidates overcome the obstacles and difficulties in understanding the course materials and examination formats. We do this through intensive classes, revisions, and examination review workshops. We do not believe in a one-size-fits-all approach, and our study sessions are focused on helping candidates understand the course material in a way unique and personal to them. In addition, we also offer private and intensive tutoring sessions for candidates who are in need of a direct one-on-one session. If you are interested in registering for our private tutoring session, please reach out to us via email at inquiries@ncaguides.com. Join me in welcoming your guide for this session. Thank you.
Oh, great. So you can hear me. Awesome. Hi, my name is Kenny Okunwola. I am the Canadian Administrative Law Guide with the NCA Guides. Today, I will be delivering the introductory classes for the Canadian Administrative Law course. To start with, I would like to state a few things. So this introductory class is meant to give an overview of what Canadian Administrative Law is. The essence of the class is to prepare you for your studies, to kickstart your personal study, and also for anyone who would also like to join our intensive classes. It's also designed for you to know what our course content is going to look like, what our regular classes are going to look like. Basically, it's much more than just a knowledge sharing session. It's also an information sharing session, so that way you also understand what we do at NCA Guides. I would like to implore us all to bring out a copy of our syllabus, our NCA Canadian Administrative Law syllabus. If you don't have that now, you can go to nca.legal, nca.legal, in case you don't know already, and you can download a copy right away, because I'll be saying a couple of things from the syllabus to guide our discussion today. So to start with, what is Canadian Administrative Law? So let's take a look at what the syllabus says with regards to Canadian Administrative Law. Then I'll tell you my own definition of what Canadian Administrative Law is. So the NCA syllabus, which was updated January 2020, effective for the May 2020 exam, which was postponed to August, tells us that administrative law is the body of law regulating the ways in which government operates. It's about the rules and limits that apply to not only the operations of the Crown, cabinets, ministers, government departments, and municipal corporations, but also the various admin tribunals and agencies deployed by the government for the carrying out of governmental functions of all kinds. It is concerned with the procedures by which all these various instruments of government operate, the substantive scope of their mandates, the remedial structures that exist to ensure the decision makers of various kinds act in accordance with the rule of law. As well, throughout the materials, candidates are encouraged to reflect upon the divide between public law and private law, and in particular, the circumstances under which the government authorities of various kinds or in various capacities are subject not to the special regime of admin law principles and remedies, but to the private law rules of contract, tort, restitution, and the like. Some regard admin law as simply a subset of constitutional law, and to the extent that, for example, the Charter and other constitutional and quasi-constitutional enactments serve to place limits or constraints on the way in which public decision makers act. There is overlap between this subject and constitutional law. However, administrative law is not about the policing of the divide between federal and provincial jurisdiction enshrined in the Constitution Act 1867 and the other statutes that constitute the Canadian Constitution. Nor does it concern itself in detail with the constitutional incidents of the Crown, Parliament, and the various legislative assemblies or the executive branch. Rather, these are the three questions that admin law really deals with. the circumstances under which the government decision makers are subject to an obligation of procedural fairness, and 2, the extent to which the substantive decisions of admin decision makers are subject to merit scrutiny by the courts, and 3, the remedial framework within which the Supreme Court, both federally and provincially, exercise their powers. So I just wanted to read that part because I'm aware that most candidates don't even take a look at their syllabus before they start studying for the course. So it's pretty much important for us to start with what the NCA, has defined administrative law to be. But in my own opinion, what is administrative law? I've always told my previous candidates, even both for the May and August exams, that to me, administrative law is simply the interaction between the 3 organs of government in Canada. Now, I'll explain in detail what I mean by that. When the parliament makes such laws, they establish an admin body, which is deemed to be part of the executive arm of government, and the executive, in exercising such powers that were conferred on them by the parliament, may do certain things that will affect or infringe on the rights, interests, and privileges of citizens of Canada. And the courts are not going to have that. So that's essentially what is happening in administrative law. So I'll give you guys a very good example. Say, for example, we are all lawyers, or we are trying to be lawyers again in Canada. So say, for example, you get summoned by the Law Society of your province. Now, whether law societies are ADMs or not, that's another question we're going to answer in the future, or maybe in our classes. So now, say you get summoned by the Law Society of a province, and you've been disciplined, say you've been disbarred, for example, God forbid, say you've been disbarred, and you want to review such decisions. Now, so essentially what has happened is they've made an administrative decision that has affected your rights and interests and privileges. Now, in making such decisions, the courts expect that the ADM, and by ADM I mean the administrative decision maker, the court expects that the ADM will follow certain principles before making such a decision. Now, see it from this other perspective. We have all been to court before. So when you go to the law courts, when you want to take a matter to court, what's the first thing you do? You fill certain forms to start the action, right? To start the processes. And then what does the court do? The court will have to notify the other party, right? So that is where you start with notice. And if you try to serve the notice on that party and you're unable to locate the party, what do? You go back to court for what we refer to as, in some jurisdictions, as order of substituted service. Essentially, what you're trying to do is you want to ensure that the other party is aware of the impending matter against them in court. And the court wants to make sure that that other party gets a chance to have their say in court. So now when you're unable to serve the notice to them, then you go and get an order to do some kind of substituted service. And you can do this by either placing it at their workplace or maybe pasting it at their entrance and taking a photograph and bring it back to court to be admitted as exhibits. And then you do that, and the court is now satisfied that, well, we've tried all we can to get this notice to this party, right? So essentially, what is the court doing in that regard? The court is trying to ensure that they follow due process, right? So now when you do that, what's the next thing that happens in a typical court setting? The next thing that happens is all the parties come to court, and then you start the adversarial process. There's you front load your documents. In some countries, they call them pleadings. You do the statement of claim, the statement of defense. You front load all the documents, the witness statements on oath and the likes. So in doing that, what you have just done is what we refer to as discovery, or in some situations, maybe disclosure. So now, why did you have to do that? Because you're also trying to make sure that whoever has to respond to such cases in court, they know the case to meet. Now, subsequently, when a party raises something, or say, for example, the plaintiff or the appellant in a typical court setting examines a witness in chief, the opposing party is entitled to do what we refer to, and you probably all know, is cross-examination. Why is that? Still in the aim of trying to ensure due process. And even if the other party finishes their cross-examination and they raise some new matters, then the actual applicant is entitled to what we also refer to as re-examination. So essentially what the court is doing in this process is just to ensure that there is due process, there's procedural fairness, nobody is marginalized by the law. Now, remember that judges are, well, I don't know about some other countries, but in most countries that I know about, judges have been called to the bar of that country. They've gone to the law school, they are aware of the legal processes. They've sometimes maybe even been lawyers before. I'm not sure if it's possible to be a judge without having been a lawyer before. Maybe it is in some other countries, but they've sometimes, been a lawyer before. So they are aware of these procedural fairness obligations. Quite all right. Now, let's come back to administrative law. Now, in administrative law, when the parliament makes a law and such law establishes a body, say, for example, the law establishes the Immigrations, Refugees, and Citizenship Canada. Now, the law now empowers the IRCC to set up an administrative decision maker that's for everybody here, except for anyone that was born in Canada, at one point in time or the other, you've had to apply to the IRCC. It used to be called the CIC, but at one point in time or the other, you've had to apply to them. And if they've ever denied your visa application before, then you can do what we refer to as like an administrative appeal. And in doing that, what you're essentially saying is that my rights or my interest or my privileges has been trampled upon, has been infringed, or my charter rights has been infringed. And I want this decision, I want it reviewed. That's essentially what you're saying. Now, remember that ADMs are not required to be lawyers. They don't have to be lawyers. As a matter of fact, there are several administrative decision makers that the decision makers are not lawyers, which means there is a possibility that they may not even be aware of this due process of the law or the procedural fairness obligations that they should afford an applicant. Or even if they are aware, or say their enabling statute has provided that you must do certain things when certain matters come before you. So say they're actually aware, then it's also very possible that the ADM may make an omission or an error in the process of observing these procedural fairness obligations. So essentially, what Canadian administrative law, deals with is the interaction between the parliament, the executive arm, the judicial arm of government. So now the courts are saying if the lawmakers make a law to empower the executive arm to determine the rights, interests, and privileges of the citizens of Canada in a way that is not procedurally fair, then the courts are not going to have that. The courts, by virtue of the rule of law, will have the inherent rights to review such decisions. Now, there's a difference between judicial review and statutory appeal. So those are the kind of things we'll be covering in our intensive classes. Because this is an introductory class, we won't be able to, it's actually not possible anyways, to cover every single aspect of administrative law. So now, before we delve into the review of all the applicable chapters, I would just like to take you guys through some of the chapters of the syllabus. So chapter one is basically setting the stage. And here, chapter one is just trying to, really give us a critical understanding of what administrative law is all about, introducing us to the relevant text, telling us about the procedural fairness obligations, what the substantive constraints are, and how to challenge admin decisions and what remedies you can get on judicial review. So now it goes without mention for anyone that probably hasn't heard about it before that administrative law can be broadly divided into two, and which is the procedural part and the substantive part. Now, the procedural part is the one I've actually been explaining up until now, which is to say that the procedure the ADM followed to arrive at such a decision must be fair. And what it means to be fair is what we will have to unpack subsequently. So what does it mean for a certain procedure to be fair? We're going to be looking at such contents, the content of procedural fairness. We also refer to them as participatory rights. So what are these contents? Things like notices, discovery, disclosure, and I have some of them here. I have some of those contents here. Yeah, we have things like notice, discovery, delay, oral hearing, open hearing, right to counsel, disclosure and official notice. Under this subheading, we're going to be looking at things like privilege, executive privilege, state privilege, spousal privilege, solicitor client privilege, and the likes, commercially sensitive information. What happens in such a situation? Are you going to release such information under the guise of disclosure, or are you going to, deny it under the guise of protecting such information and infringe on the charter rights? What to do in such a dilemma? What has the court told us? Things like staff studies, cross-examination, reasons, bias, institutional issues. What happens when an ADM decides without hearing, or a member of the ADM decides without being part of the hearing board? Where there's an overlap of function, maybe in cases where an investigator is also a member of the decision-making body. What happens when an agency counsel writes the reasons for the decision? So those are the things that we're going to be looking at in our discussion. So going back to what the syllabus is talking about, procedural fairness, we're looking at the procedure. Exactly, that's what it says. Now, when it comes to the substantive constraints, that is entirely a different thing. Now, for the substantive constraints, we are not looking at the procedures anymore. What we are looking at is the actual decision. Now, remember when there's a decision from the ADM, there's a part of looking at the procedure, whether it is fair. That's not what we're concerned with right now, but we're looking at the decision itself. So I'll give you guys an example. Say, for example, I apply for study visa to Canada and it gets denied for no cogent reason, and I want to appeal such a decision. Now, if I am appealing on procedural grounds, what I'm exactly telling the court is, I am telling the court that this decision was not fair because they didn't follow the proper procedure. I am not saying the decision itself, the actual outcome was wrong. That's not what I'm saying. I'm just saying maybe they didn't give me notice, I didn't know they were, or they didn't tell me the case to meet. Or maybe, for example, I asked them for the reasons for denying me that study visa and they didn't give me a cogent reason. They said, well, we denied you because we don't like your face. Or maybe, well, that's an entirely, whether reasons are sufficient is an entirely different discussion that would also talk about in our intensive classes. So now, but when we look at the substantive constraints, we're not looking at the procedures at all this time around. We're looking at the actual decision. Here we are looking at whether the decision is reasonable or whether it's correct. Now, in knowing whether the decision, the substantive decision itself, is wrong or not, you need to now identify what standard to review such decisions on. Because you can't just look at the decision and say, well, I think this decision is wrong. You can't just do that, really. You need a standard. Now, to arrive at this standard, there's been a lot of history. Now, initially, it started off in the case of Bibo and progressed up to the case of Dunsmuir. Now, before Dunsmuir, we used to have three standards. We used to have the standard of patent on reasonableness, simpliciter, and correctness. So it was more like a spectrum. Let me just stop sharing this so I can see our faces. So it was, as a then, it was more like a spectrum. So we had like patent on reasonableness on the one hand, reasonableness, simpliciter in the middle, and then correctness. So correctness is the less differential standard, while patent on reasonableness, well, correctness was a less differential standard, but patent on reasonableness and reasonableness simpliciter are a little bit more differential than correctness. Because when the court is reviewing your decision on a correctness standard, the court does not want to give you any form of deference. And what do we mean by deference? Deference simply means you are deferring to the expertise of that ADM. That is, you expect or you believe as a judge that this ADM is an expert in their field. So what does it mean to be an expert? Say, for example, you are an immigration officer, review officer of some sort, or you work with the Securities Commission as a member of their ADM. It is expected that you will probably know more than the judge, right? Because you are a subject matter expert. So as at that time, pre-Dunsmuir, expertise was a big deal. So pre-Dunsmuir, or even pre-Vavilov actually, expertise was a big deal because once you're an expert, there's some ton of deference from the court, right? Now, when Dunsmuir was released, what we came to discover was that the court now decided and said, you know what, we are no longer going to work with 3 standards of review. We're just going to work with the standard of reasonableness and correctness. So now it's no longer the 3 standards of patent or reasonableness implicita, and correctness anymore. So it's now just 2 standards of reasonableness and correctness. That was what the case of Dunsmuir did. Now, in addition, Dunsmuir also introduced what we refer to as the default assumptions. Now, this is all history. I just want you guys to listen and understand, the concept of substantive review and how we got to where we are today. So all I'm telling you right now is history. So now, default assumptions was introduced by Dunsmuir, and Dunsmuir started telling us that when you see certain factors, before Dunsmuir used to be the pragmatic and functional factors, which are 4 factors that we use to determine the standard. I won't mention them because they aren't so important right now. But now Dunsmuir came up and told us that we have to rely on things we refer to as default assumptions. So Dunsmuir is saying the moment you see these factors, just know that the standard is going to be correctness. And what are these factors? Things like constitutional questions, questions of central importance to the legal system, and outside the area of expertise of the ADM, questions of jurisdiction between 2 administrative decision makers, question of true jurisdiction too. So those were the default assumptions. And Dunsmuir started telling us that, well, as soon as you see these factors, if it appears in any of your scenario for a candidate in an exam, or even actual practice, it appears in the fact of the case of your clients, simply know that this is going to be reviewed on the standard of correctness. Otherwise, then it will be reasonableness. So Vavilov kind of refined those default assumptions. But before we get to Vavilov, let's make some progression in other cases that came after Dunsmuir. So subsequently, we had the cases of Koza, Newfoundland nurses, and several other cases where the court now revived the pragmatic and functional factors that came before Dunsmuir, which caused a lot of issues and unnecessary burden on candidates that were writing Canadian administrative law at the time, myself included, because I wrote my exams in the dispensation of Dunsmuir, and it was not pretty, to be sincere with you guys, because the simple implication of that is, for you to arrive at a standard as at that time, you need to now combine the pragmatic and functional factors pre-Dunsmuir and the default assumptions post-Dunsmuir, because they were both Supreme Court decisions, the ones that abolished and the one that omitted to talk about it, and the post-Dunsmuir cases that revived those factors. Now, the implication is the Supreme Court did not give us a definite direction as to whether one was dead or alive. So for examiners and for candidates, we had to write both. The good thing as at that time was, if you apply both factors, you will almost always come to the same conclusion. So that was how we wrote our exams then. Now, Vavilov came December 2019, and Vavilov started telling us that, you know what? The pragmatic and functional factors are dead. The default assumptions on that Dunsmuir, we are refining it. And now, welcome to the era of presumption of reasonableness. And that is what Vavilov is telling us. So Vavilov introduced the presumption of reasonableness. And Vavilov said, or let me say, says that, first step in identifying the standard of review is to start with a presumption that it will be reviewed on a standard of reasonableness. That is what Vavilov is telling us. Then, like any presumption, it can be rebutted. And there are 2 ways you can rebut this presumption. And let me show you these 2 ways briefly. I may still have to go back to some other things. I'm just trying to, give like an overview, and then we may have to go deeper into some other things before we leave. So now, Vavilov says, start with a presumption of reasonableness. And this presumption can be rebutted in 2 ways. So this presumption can be rebutted in 2 ways. Number 1, legislative intent. Number 2, by the rule of law. Now, for the legislative intent category, by the way, guys, I was going to mention this. The MCA guides, we have this material called, we refer to it as the Administrative Law Answer Framework. I actually put this material together, and I used the same material when I wrote my Canadian administrative law exam. So it is not a material that is just out there. It is not just any other IRAC out there that people just put together and they hope you pass with it. I passed my exams with it, and several hundreds of NCA candidates have also written their exams with this framework. Now, what does this framework do essentially? This framework is not a note. It is what it says it is. It's an answer framework. Specifically, it helps you because the thing about administrative law is it is a long narrative. It is not like foundations or constitutional law where you have to be branching left, right, and center before you come to your conclusion. Admin law is like see it as an essay. But unfortunately, the syllabus does not structure itself the way you're supposed to answer your exams. For example, there are certain items like venue for and basic procedure for judicial review. This is not essentially what you are going to write last in your exam. In most occasions, it may even be what you have to write first. Or maybe if you want to look at discretion of the court for granting remedies, it may not even be what you have to write first in the exam. And there are also some preliminary questions that you have to answer before you even know whether judicial review is available. So what we basically did with this framework was we essentially tried to put everything together in the order you are expected to answer it in the exams. And I'll give you guys a guided tour of the framework. So say, for example, I've got this structure for procedural fairness review. I came up with this structure. I call it the STTC structure, sources, triggers, threshold, contents. It essentially helps you to know the different sources of procedural fairness, what the triggers are, the threshold, exactly how you're supposed to structure your discussion. So I'll give you guys a preview of the first page. So say, for example, you're supposed to start your discussion like this. Now, let's go to what we're talking about right now, how you can rebut the presumption of reasonableness under Babylon. Now, there are pointers to what a constitutional question is, what a question of central importance to the legal system is, and then it tells you, the framework tells you what to do. The framework tells you the next step after each of your question. Then if you have to apply a standard, the framework will tell you can insert the nature of the question here. The framework may also tell you where to insert facts from your scenario. So the implication of this is that you can practically write this framework down in the exam because everything that has been taken from a textbook or from a case has been referenced in the framework. So you can insert applicable fact from your question. So you don't have to get stuck when you're writing, because what happens is it's not the case that candidates don't even know. It's about 25 pages. And I can assure you, you can't write 25 pages in the exam. It's not possible. So what I've discovered is that candidates they understand these principles. As a matter of fact, it is impossible for you to go through our intensive classes and not understand what we are talking about. You will be ready for the exams. However, there are instances where candidates may be ready for the exams, but when it gets to the exam proper, they are now wondering, how do I start to write? Unfortunately, admin law, like I say, is an essay. It's a narrative. If you don't start with the right thing, you will end up with the wrong conclusion. So, for example, you have to identify who your ADM is. Now, how do you identify who an ADM is? Those are the things we'll be discussing in our intensive classes too. There are several pointers, whether it's a public body, whether it's established by law. Will the Canadian Charter of Rights apply to your ADM? There are several ways to look at that question too. So, you will need to look at some of these issues. And candidates can get stuck in the exam and they're now wondering, how do I start my discussion? What should I write first? Now, I wrote criminal law first when I was writing my NCAs. And I made that same mistake too. So it is not something out of the ordinary. It doesn't mean you are not brilliant. It's just the examination tension. When I was answering my criminal law question, I had written actus reus, pens rea, and I was going to conclude, only for me to remember that, I didn't see anything about causation, So if there had been a structure like this, there is no way I would have forgotten and have to now backtrack to now go and complete what I missed. So essentially, this is what the framework is doing. However, it is not a replacement for your notes, because you will not even understand the framework if you have not read your notes. But the moment you've read and you've gone through our intensive classes and you have this framework, I can guarantee you that you will pass your admin law exams. And in the unlikely event that you don't pass, you are even, I can assure you that you will get access to our intensive classes without any cost. If you go through the intensive classes the first time and you don't pass, you will get access to it without any cost. That is to tell you how confident we are in our methods. So this framework on our website right now, it costs $100, 100 Canadian dollars, but it's on sale. It's on sale for $75 right now. However, candidates that register for our intensive classes, or let me say for the administrative law intensive classes, because if you register for another course, it doesn't necessarily mean it's an admin law course. So if you register for administrative law intensive class, you will get this framework at a heavily discounted price of $30. It is ridiculous. We've never done that before. Everybody that has bought this framework and that wrote the exams in August, I mean, everyone came back and said, it was awesome. I didn't know it was this awesome until I actually opened it. And I think, okay, I'm not sure if anyone here wrote in August. So I can assure you it is worth the price it's selling for on the website. So if we are giving it to you at a heavily discounted price, it is because we are encouraging you to, to be a part of our classes. It doesn't mean it doesn't have any value. So register for our intensive classes. You get it at a heavily discounted price of $30. So now back to our discussion. So now legislative intent, that's how you can rebut the presumption of reasonableness. And the second way is by the rule of law. So now what does it mean when we say legislative intent? Here we are saying two things. Number one, you have to look at your statute and ask yourself, is there an express provision of an applicable standard in this enabling law? You have to look at that law and check very well and ask yourself, is there an express provision of an applicable standard? Did the parliament say that this standard should apply? If there's anything like that, then the standard will apply. So what are we saying? What is the court doing with this? So remember that before we came to Vavilov dispensation, under Dunsmuir, the court didn't really care about what the intention of the parliament is. They never really cared so much. But now the court is paying more attention. So there is this interesting article in Foundation where an author mentioned and said the dialogue that the court and the parliament, they try and engage in a dialogue. That when there's an error in a law that comes before the court will give the parliament an opportunity to amend such law. But another author said it's not a dialogue. It's more like a monologue, like one person is speaking and the other person is listening. That is, the court speaks, the parliament listens. Once the court says this law is wrong and they overrule the law in their court, the parliament has no choice but to amend the law. But now, by this, legislative intent subcategory in Vavilov, what we are seeing here now is that the parliament or the courts are gradually moving towards, respecting the intent and wishes of the parliament or the legislature. And that is what we call this the legislative intent category. So if the legislature has, if they've provided that this is a standard that we want to apply to any matter involving this ADN, then the court will follow that standard. That's the first way, to rebut the presumption of reasonableness under the legislative intent category. Now, the second subcategory under legislative intent is what we call the statutory appeal mechanism. Now, here we are actually asking ourselves if it's, if it's a question of law or question of fact or mixed fact and law. If it's a question of law, it will be on the standard of correctness. If it's a question of mixed fact and law or question of fact, it will be a standard of palpable and overriding error. So in my experience tutoring candidates, the overriding concern that I've gotten from candidates on these subcategories, how do I know what a question of law is? How do I know what a question of fact is? How do I know what a question of mixed fact and law is? Simple answer, well, I wouldn't say there's a simple answer. I would just say we'll be going through this in our intensive classes too, because there are several angles to look at. We're going to have to look at whether the question, now, I'll give you guys a very simple example now, so that you can, but we'll be looking at it in detail when we get to the intensive classes. Now, so a very good example of this, question of fact are questions that are specific only to the case at hand. However, questions of law are questions on how a law should be applied, not just to the case at hand, but generally speaking. Now, I have an example here that says, if Joe gets fired because he was caught drinking alcohol on his lunch break, but he sues for wrongful termination, claiming that he's an alcoholic, and that there are laws protecting him from being fired because he considers his alcohol addiction a medical condition, the first question to decide in this case is whether or not Joe's drinking was a result of alcoholism. That would be a question of fact, because it's only specific to his case. Now, the second question will be whether or not there is any law that grants him job protection, and that would be a question of law. So again, we'll be looking at everything in detail when we start the intensive classes. Okay, so moving on. So now, when you now come to discover and you have concluded that your question is a question of law.
Hello, sir. Could you just please repeat the question of law part again and the fact, please?
Okay. So like I said, a question of fact is a question that is specific only to the case at hand. And a question of law is a question on how a law should be applied, not just to the case at hand, but generally speaking. So in administrative law, you will see when we're talking about laws generally, and you will see this when we're talking about legislative decisions and emergencies as an exception to the application of procedural fairness. When you're looking at things that has to do with law or legislative decisions, it will always have to be general, because the moment it is specific, then it's no longer a law, it becomes like a decision. And I mean, if you look at, for example, when we look at, let me just quickly take you guys to that part of the syllabus. I'll come back to it when we get there. I just want to quickly make a point with that before we move on to answer the question that was just raised. So yeah, so chapter 4 says legislative decision and emergencies. So here it says it's a procedural obligation trigger, but it's actually not a trigger. It's an exception. And you see what the syllabus is saying here, saying common law procedural fairness rules may also fail to be triggered where there are emergencies and where a decision is said to be of a legislative nature. Now, and here the syllabus is also saying that a legislative decision means more than this. It's not just a delegated legislation, but boiled down to its essence, it can be a decision that is sufficiently general. So now going back to my jottings. So questions of fact are questions that are specific only to the case at hand, but questions of law are questions on how a law should be applied, not just to the case at hand, but generally speaking. And I give an example of Joe. If he gets fired because he was caught drinking alcohol on his lunch break, but he is now suing for wrongful termination, saying he's an alcoholic, and there are laws protecting alcoholics, right? What we are now saying is that whether Joe is an alcoholic, whether Joe drinking was a result of alcoholism and not bad judgment, that would be a question of fact, because we will have to look at Joe's situation to determine that. It doesn't necessarily mean any other applicants will have the same situation applied to them. And that is why it will be a question of fact. But when we are now looking at whether or not there's any law that grants Joe protection, that will be a question of law. Because here we are no longer concerned with anything that is specific to Joe anymore. We are now interested in even knowing whether Joe can get protection under the law. So that is not specific to him. That is general.
Thank you. Thank you.
Yeah, you're welcome. So now the moment you've decided and you've understood what your applicable standard is, so the next thing, okay, so yeah, so sorry, we're still on legislative intent. So now let's go to the second rebuttal. Remember, we started with presumption of reasonableness can be rebutted in 2 ways. And now the second way you can rebut it is by the rule of law. Now, under this rebuttal category, the correctness standard will always apply. And here we have questions like constitutional questions, jurisdiction between two or more ADMs, and 3, a matter that is of central importance to the legal system. One fantastic and interesting thing about this rule of law subcategory is that it is a refined version of the default assumptions under Dunsmuir that I mentioned earlier. Remember, under Dunsmuir, we had constitutional questions, jurisdictions between 2 or more ADMs. Number 3, matters of central importance to the legal system and outside the area of expertise of the ADM. And the 4th one is true questions of jurisdiction. But under Vavilov, the court eliminated true questions of jurisdiction or questions of true jurisdiction. I don't know how, I can't remember how it was phrased. And the court also removed expertise as a factor under this category. So now it is just matters of central importance to the legal system. Now, under Vavilov, the court contemplated what this will mean. And we're going to be reviewing that in detail because the Vavilov case is a very vital case to administrative law. So we will be reviewing that in our intensive classes. What does it mean when what is the purpose and implication of the removal of expertise as a condition for this part of this category that was under Dunsmuir, now under Vavilov? It simply means there's a floodgate that has been opened. And like I mentioned that in my framework for people that buy it, and by the way, you don't have to be a part of our class to buy it. It's just that you will get, you get that a subsidized amount, heavily subsidized amount if you buy it. And you will see that I included pointers to what constitutional questions are, pointers to what questions of general law of central importance are, and other things like that. So now what happens then now is that we will now start looking at what happens. Questions of central importance to the legal system. Before, this category used to be very limited because we used to consider whether it is also outside the area of expertise of an ADM. But now that expertise is no longer a factor, it means that any matter can potentially raise, importance to the legal system. For example, matters that relate with, there was something that the, so let's take a look at what Vavilov says. There was something under paragraph 244 of Vavilov, and I think I included it in the framework. Paragraph 244 of Vavilov. Abela J. and Karakatsanis in Vavilov, they mentioned that issues of discrimination, labor rights, and economic regulation of the securities market, among many others, they theoretically raise questions of vital importance for Canada and its legal system. So essentially what they are saying, and that was a concurring decision, by the way, in Vavilov. So what they were saying in that case is, the removal of expertise will potentially raise, a lot of concerns for this subcategory because it will open a floodgate. And what that means for this rebuttal category and how to perfectly understand it for the purpose of your exam, we'll also be examining that in our intensive classes when we start. And by the way, the intensive classes are, they are slated to, we are starting them in 2 weeks. So the classes are holding on Saturdays. I think it's supposed to be the same time. So you can go to our website, www.ncaguides.com, and check the schedule for anyone that is interested in registering. It's every weekend because we understand that we are busy people and we may have to work during the week. So it's going to hold every weekend on Saturdays for Canadian administrative law. So now back to our syllabus. So now I have given us a fair idea of what procedural fairness entails and what the substantive aspect entails. Now back to the procedural aspect. Remember STTC, sources, triggers, threshold, and content. You have to start with what we call the sources of procedural fairness obligation. For you to claim that there is a procedural fairness breach or that there has been some kind of infringement on your right because of procedures, you have to ground that claim in a source. And the first source you start by looking at is the enabling statute of the administrative decision maker. Now, what is the trigger of such a source? The trigger will be in the statute itself. What does this mean? What does this imply? There's a whole lot to that conversation. And we'll be looking at several examples. Now, is the threshold for application met on the facts of the scenario? Now, you go to the common law. When the statute is silent on a certain procedural right, then you'll need to now look at the common law. to look at whether the common law can help you fill that lacuna. Now, however, there is a caveat to that. The common law can help you fill in a gap if the statute fails to provide for a procedural right that is missing. So, because if the right is not missing, you don't need to go and trigger the common law for it. When I say missing, that is, if you're looking at a scenario and you have itemized the procedural fairness right that ought to have been afforded your applicant, and you cannot find a certain right in the statute, it means you still need a source to ground your claim for that right. And if the statute is silent, then you now look to the common law. And in triggering the common law, you have to look at the case of Knight versus Indian Edge, where the court laid down 3 factors to let us know or to help us determine if there will be a general common law duty of fairness. And those factors, we refer to them as the Knight 3-prong test or the Knight 3-prong factors. Now, these Knight 3-prong factors, they are, I like to refer to them as mutually inclusive. That is, you need all 3 factors to be triggered before you can say common law duty of fairness, will be available. Now, you can also trigger common law by a concept that we refer to as legitimate expectation. I'll talk about that shortly. However, I need to just mention one caveat. The common law can help you fill in the gap in the statute, but the common law cannot change the statute. I'll take that again. The common law can help you fill in the gap in the statute, but the common law cannot change the statute. If you need to challenge the statute for any reason whatsoever, then you need to look at the Charter or the Bill of Rights. And here, before we get to that, I'll just talk about the Knight 3-prong test and the legitimate expectation factors shortly. So these Knight factors, they got 3 tests. The first one is the nature of the decision. The second factor is the relationship between the decision maker and the applicant. And the last factor is the effect of the decision. So those 3 factors need to be triggered. You need to apply them to your scenario before you can conclude that the common law duty of fairness has been triggered. Now, there's another way you can trigger common law, which is called legitimate expectation. So what is legitimate expectation? Legitimate expectation is essentially saying that you had an expectation that was legitimate. That is, you really expected that something was going to be done. And there are 2 ways that legitimate expectation can be triggered. Now, some notes for those of you that have started reading, some notes we say 3, but essentially it's really 2. The first factor is by express representation. The second factor is by implying it from practice. And the third one that most notes out there we state is a combination of both. So now I'll give us examples and I'll ask us a question after to tell me what you think is the answer. Now, example of something that can be implied from practice. Say, for example, there is and this applies mostly to union of workers. Say, for example, there's a union of workers where before any staff is fired or laid off, they have to consult the union first. Now, when the pandemic started, say, for example, people started, a rumor started going around that they're about to start laying off people that are a member of a certain union. And the union leader now comes out and tells everybody that, no, don't worry about it. They will never lay anybody off until they have consulted us. And I can tell you that they've not consulted anybody. And because we know they always carry out this practice before they lay people off, I can assure you that you will not be laid off. Now you are aware of the practice, and now you have a legitimate expectation that based on that practice, that they will still follow that practice. Now, if that doesn't happen and they lay you off, you can claim that you have a legitimate expectation that you were going to be consulted, or the union was going to be consulted first before the layoff occurred. Now, I'll give you guys an example, and I'm going to ask about 10 people what they think in distinguishing what, before I go to the example, I would like to mention one thing. Legitimate expectation, however, has some caveats. The first caveat is under the one that can be implied from practice. You cannot claim legitimate expectation that was implied from practice if you were not aware of that practice. So if you were not aware that they always consult the union association before they lay anybody off, you cannot claim that I had a legitimate expectation, because You did not expect it. And even if you expected it, it was not legitimate. So there's no way you can claim it. Now, candidates in my tutoring experience, the question I always get back from candidates when I say that is, they'll be like, but how will they prove that I knew or I did not know? And I will tell them that this is not constitutional law class, this is not criminal law class. Nobody is asking for you to start to show your adversarial skills in your exams. If the examiner wants to tell you that the person or the applicant was not aware, it will be crystal clear in your scenario. It won't be something that you have to argue. Now, if they now ask you to state assumptions, that is an entirely different ballgame. If they ask you to state assumptions, then you can state the assumption that you assume that your assumption is that this guy was not aware or this applicant was aware, then that is an entire different scenario. But if your question is already stating that the applicant did not know about it, then you cannot argue it. Then it simply means that it cannot rely on it because it wasn't aware of the practice. Now, the second caveat, which is what, and I want you guys to listen with rapt attention. The second caveat, which is what my question and a little brief interactive session will be based on, is that legitimate expectation cannot be used to generate a substantive outcome. Now, I will explain what it means by a substantive outcome, and I will now give you guys an example, and I want you guys to tell me whether that's a procedural outcome or a substantive outcome. So essentially, legitimate expectation can be used to generate a substantive outcome. It's only applied to a procedural outcome. If you were promised a substantive outcome, the best you will get out of it is higher degree of procedural fairness protection. So now, what is a substantive outcome? A substantive outcome is a definite outcome, a definite decision. And a procedural one is the one that has to be, that has to do with the procedures. So now a very good example. And I'll ask you a question now. So the NCA, because of the migration to the online exams and the pandemic and the burdens on the candidate, decided and made an express representation on their website and via emails to candidates that you will all get 1 hour extra during your exams. And a recent email was even sent out for the October candidates that October exams too will also run for 4 hours. So say as a candidate, you now get to the exam, well, it's in your room now, so it's not an examination hall anymore. You get to your exam hall in your house and you open up your computer, you log on to Monitor Edu or whatever software is being used at the time, and you now realize that your exam is for 3 hours, not 4 hours. So tell me, do you think now you now want to ground a claim on legitimate expectation basis? So do you think that promise that they will add 1 extra hour is a procedural promise or a substantive outcome? So I'll leave, this is the period for you guys to switch on your videos and switch on your mics. I'll just call people randomly. Anu Nijara, I'm not sure if that's the right pronunciation. So do you think that's a procedural promise or substantive promise?
Substantive.
We can hear you clearly.
I think it's substantive.
Substantive? Okay, why do you think it's substantive?
Sorry?
Why do you think it's a substantive promise? Adiola, do you want to help Anu out?
Sorry?
Adiola.
Okay.
Okay.
I think it's procedural.
Okay.
Because from what you explained to us just now, it can't be used to generate a substantive outcome. It only guarantees a procedural outcome. So I think it's procedural because the NCA website made they made a promise, and from that promise, we already have a legitimate expectation from it. I hope I'm correct.
Okay, thanks for that. Bimpe, what's your take on that? Do you think it's a procedural promise or a substantive promise?
Can I add something? Is this
Manura.
Yeah,
okay,
is this a substantive promise because the enabling statute doesn't talk about 4 hours because of the pandemic, the situation has got worse and NCA has been forced to enact a new law or a bylaw or a regulation that they will give us 4 hours. In that sense, this is a substantive procedure.
Okay. Randy, do you want to weigh in on that? Randy? Randy, are you with us? Temi.
Hello.
Hi, Temi. Do you want to weigh in on that? What do you think? Do you think that's a procedural promise or a substantive promise?
I think it's substantive, but I'm not sure.
Okay, why do you think it's substantive?
Because it's the NC had already told us specifically that this is what's going to happen, and I also think maybe because it goes to the main point of the exam that you've been informed already, and that's what I think. And then on the exact date for the exam, you find out that it's actually 3 hours, not 4 hours.
Okay. Ife Oluwa, what's your take?
Hello?
Hi, we can hear you.
Okay. Your statement is what has confused me right now. When you said that legitimate expectation cannot be used to generate a substantive outcome. Well, ordinarily, looking at the scenario that you gave us, I would have said that it's a substantive outcome. But based on the statement you made, it appears to me to be a procedural one.
Why do you think my statement has affected it? Is it because the fact that the NCA has granted it does not mean, it doesn't mean it's still not a substantive outcome. If we only, the fact that you won't be able to use the legitimate expectation to generate a substantive outcome, we only come up when you are claiming for it and the NCA has refused to comply. So say the NCA refused to comply and they are claiming it's a substantive outcome. Would you say it's a substantive outcome or will you say it's a procedural outcome, and why? And I know you've not all read. I just want you guys to weigh in on that.
Yeah, I would say the substantive outcome because apart from the announcement, they sent the information round to every candidate that this is what is going to occur. It's going to be 4 hours. And so necessarily everyone are prepared in that line. And to now come to the exam and then you give them 3 hours, I think it's a breach of some sort. So in my opinion, it's substantive.
Okay, thanks. Before I call the next person, let me just break down this question so that you understand it further. So what's a procedural outcome? Something that has to do with a procedure. And what's a substantive outcome? The substantive outcome, usually there will most likely be like one substantive outcome in a situation, or maybe there will be more, but it will have to be definitive. It will have to be something final, something really concrete. I'm trying not to give you guys too much tips. So now, do you think that the fact that they granted you 1 extra hour is a definitive outcome where your exam is concerned? I'll let you okay, someone wants to say something.
Yes, personally, I would say yes, because it's going to obviously affect the impact of the exam from the candidate's perspective. I know we can say this procedure, but the fact that we have been informed and then already prepared based on that information that you're working with 4 hours, there is no how that is not going want to go into the fundamental issue of the exam. Fine, it might be a process. Maybe it's just one of the procedures for writing the exam. But to me, as a candidate, I would see it as something substantive with enough impact on how the performance in the exam or the outcome of the exam would be. So I think I would still go with substantive, but I'll wait for you to tell us.
Nkiru, what's your take on this?
So, Munira, my question is, substantive outcome will only come in the situation when the enabling statute or anything that has the source of the legislation has not talked about it, but the situation has given us an impact that we have a legitimate expectation of an outcome. Is this what substantive is?
Is it? Are you asking a question or is it a contribution?
Both.
Both. Okay,
I just wanted to
I'm
make
going
sure
answer.
that I understand,
No,
because I understand
I'll answer
procedural
it, don't
fairness.
worry. I'm going to give you an answer. I just want to
Yeah,
stimulate
sure.
the idea.
No
The idea
problem.
behind this introductory class is that, I mean, when I was writing my own exams, even when I finish one course and I'm switching to the next one, the switch is always very difficult. How much more for someone that has not even written any exams and you're starting for the first time? So I'm assuming there are people on this call that are either starting for the first time or they have written several exams and they're about to switch to admin, which means you are switching to something entirely different from what you've been reading. So the aim of this discussion class is to stimulate your intellectual curiosity as far as reading is concerned. Now, when we are done with this class, you're supposed to pick up your notes and, the issues should start jumping at you and administrative law should start looking like your best course. So, and that is why I want you guys to really participate in this, interactive session, because there is no way we will finish this interactive session and you will ever forget what legitimate expectation and substantive outcomes are. So, Paula, can you weigh in on this, please? And by the way, if I ask you a question and you are not interested in answering, I will still expect you to give me feedback that I want to take a pass. But if I call you and you don't answer, I'm going to remove you from the call. I've already removed 2 people from the call so far. I just didn't announce it earlier because I assume that if you're on this class, I can't see your face and I've been talking for the last 1 hour and you still don't want to, grant us the etiquette of just saying, I want to take a pass, then you are probably not in the class. So I'll just remove you from the class. So please, if you don't want to answer, just tell me, I'll pass. All right, so Paula, do you want to weigh in on this? You're muted. You're muted, Paula. We can't hear you.
Sorry. Can you hear me now?
Yeah, we can.
Okay. I think it's substantive action because something triggered, something warranted the NCA to pass that decision.
Okay.
Yeah, it's not something that they ordinarily do.
Okay.
So I think it's substantive. It's not procedural. Right.
Well, thanks for the attempt. I really appreciate it.
You're welcome.
Nkiru, are you ready to give us your input? Or do you want to take a pass?
This one is so dicey. I think it's will I just say it's procedural, right? They're changing procedures just because of a particular thing which has occurred, right? So to me, I'll just go with procedural.
Okay, thanks. Okay, I'll give you guys the answer. So let me give you another scenario that relates to the NCA, then you will understand. So now what the NCA has promised is that you get 1 hour more. And that is what we want to know, whether it's a procedural promise or a substantive outcome. Say they give you another promise and they say, if you enroll for an online exam, you have automatic, oh, no, let me not even say that. Let's say they will give you a promise that based on all the irregularities that happened, candidates waiting for 5-6 hours before they could log in, candidates being logged out, and several issues that marred the first online attempt for the NCA exam, that because of that, every candidate has automatically passed their exam. What outcome do you think that one is? Substantive or procedural? Well, I'll answer. It's a substantive outcome. So now, if they are telling you you're going to get 1 more hour for your exam, that's not substantive, that's procedural. And I'll explain further. Let us stop looking at NCA exam as an exam. Just picture in your head and imagine that the NCA exam is an oral exam that you have to appear before the examiner. Say I am the one that will mark your Canadian administrative law script. And I'm saying you have written your exam like a brief. Now see it as an admin decision. Bring your exam that is a brief, like your written submission, and come before me and present your written submission to me. And now I just told you that because you will be presenting it to me online, I will give you 1 extra hour to make your presentation. That is almost like oral hearing or written hearing in a typical hearing scenario. That is a procedural aspect of a decision-making process. It's not substantive. But if I tell you that the moment you appear before me to present your examination script orally, that automatically I will tell you you have passed when you are done. So it's similar to the IRCC telling an applicant that at the moment you submit your study visa application, you have gotten approval. It is definitive. It is not a procedure. It is an actual outcome. And the problem with that is legitimate expectation cannot be used to generate the substantive outcome itself. So even if a decision maker promises it to you and they give it to you, well, all well and good. If the NCA promises anybody that was marred by irregularities in the exam that you have passed and they actually pass you, all well and good. But if they renege on that promise, you cannot do anything about it. The best they will do is to now grant you higher procedural fairness protection. And in this instance, they can say, well, we will allow you to write again in September. So do you guys understand that better now? Okay, so now let's go back to, well, I forgot I was sharing my screen all along. I'm guessing you guys couldn't see my face. Anyways, so let's go back to our sources. So now we're done with the common law and we're done with legitimate expectation. So for the Canadian Charter of Rights and Freedom, the trigger for the Canadian Charter of Rights is Section 7. And in looking at Section 7, you have to consider life, you have to consider liberty, and you also have to consider security. Now, for Section 7, you don't need all 3 to be present in your scenario. One is enough. One of them is enough. So if life situation is present or life is threatened, Section 7 is triggered. If liberty is threatened, Section 7 is triggered. If security is threatened, Section 7 is triggered. It is very rare for you to see life situations in admin law, but it's not impossible. And mostly you most likely see immigration cases, maybe like Baker versus Canada that was on humanitarian and compassionate grounds. And you see some other immigration cases where like an applicant will say, if you deport me, they will kill me in my country. If they deport me, I may be a victim of political assassination. Or you may say I'm gay, and if you deport me, I'm going to be imprisoned in my country because it is against the law to be an homosexual or whatever. And another thing is liberty. So liberty here is basically talking about, well, the definition of liberty as we already know it, where maybe your movement is restricted of some sort. But, you know, we'll also be looking at the different dimensions of liberty that the court has espoused for the purpose of admin law for us. Now, we'll look at cases like some cases I refer to as inmate cases in our intensive classes. There are several of them, about 5 or 6 of them, which we are going to examine in detail. And in those cases, one of the applicants was claiming that he was already in prison. The funny guy was already in prison and he was being transferred to another prison. And the guy was claiming that his liberty has been infringed. And, you know, the people started wondering that, well, dude, you're already in prison. What liberty are you talking about? And the court gave us a dimension and said, well, if you are moving from a minimum security prison to a maximum security prison, your liberty is engaged again. And I always give an example to my intensive classes candidate. I'll tell them that, has anyone seen Prison Break? If you have seen Prison Break, you know, you've seen season 1 and you've seen season 3. Season 1 was Fox River, season 3 was Sona Prison. There is a huge difference between those 2 prisons. So if you get moved from Fox River to Sona, you can still claim that your liberty has been infringed, because when you enter Sona, the only way you come out is when you're dead. So now the court told us that there's another way liberty could have been affected. Now the court gave us another dimension, which we'll also be looking at in detail, and we will look at how we can apply it in our exam, which is the case of Wilson versus BC Medical. And the court was telling us that, well, if there is some kind of infringement on how you can practice your profession, liberty could be infringed. And that guy successfully won that case. So now there's a lot to that statement. And I don't want you to take it on the surface, because there's a whole lot that the court said in that case, which we'll be examining in details too later. So now, if you can successfully claim that liberty has been triggered, then you can say Charter of Rights has been triggered. Then the last thing under Section 7 is security. And here, a very good example of this was in the case of Blanco, where the court said, psychological stress could mean, if it is state imposed, it could affect, you can grant a claim on, security for Section 7. Then for the Bill of Rights, specifically, we're going to be looking at Section 1A and Section 2E. Can a corporation, can they lay a claim under Section 7? If they can't, can they lay a claim under the Bill of Rights? Does the Section 7 of the Charter apply to a corporation or not? Does the Bill of Rights, why do we still need the Bill of Rights? What is the purport and intent of the Bill of Rights when we already have Section 7? Because the Bill of Rights provision is almost similar to Section 7. So why do we still need the Bill of Rights? Those are the kind of questions that we'll need to answer for you to say you have a good grasp of how to apply these sources. Because if you don't understand why you need the Bill of Rights, then you may be wrongly applying the Bill of Rights when you should be applying the Charter of Rights. And remember, administrative law is a narrative. You miss one step, your conclusion is going to be wrong. And unfortunately, and I've seen many questions that candidates, based on the feedback I've gotten from candidates, and even based on our own exams, admin law is usually 3 questions or 1 question. That's the way the NCA is always going about it. It's always 3 questions or 1 question. If it's 3 questions, 1 question is going to carry minimum of 65 to 85 marks. And if it's 1 question, then it will be 100 marks. So basically, there's always 1 question that will still determine your fate in the exam. When I wrote my exam, number 1 question was 10 marks, number 2 was 85. The third one was 5 marks. Well, I didn't bother answering the third one because it was a waste of my time. I just assumed I was going to pass with the 95 marks I already answered. So what I'm trying to tell you guys is, whether you get 3 questions or you get 1 question, there is that 1 question. I mean, even if 1 question is 65 marks, if you miss that question, you won't be able to pass admin because the pass mark is 50, right? And 1 question already covers 65. Or in the event that it covers 85 or it covers 100, which means you will need to know how admin law works. It's not like, I mean, foundations exam, for example, now, usually you may have short answer questions, or you may have maybe 25 marks questions, and you may be able to, say, well, if I don't get it here, I may get it here. But admin law is like the opposite. You have to get it there. Otherwise, you have to get it the next diet. So essentially what I'm trying to say is, you will need to understand how each and every one of those, sources, they apply. And there's another thing we refer to as the general procedural statutes, or we call them the general statute about procedure. So these are essentially provincial laws. A very good example of that is the Statutory Powers and Procedure Act in Ontario. When do we need to apply these general procedural statutes? How does it interact with these other sources? What are its triggers? How do we know its threshold? Those are the kind of questions you will also need to sufficiently answer. Now, when you're done with your sources and your triggers and your threshold, the next thing is to now go to content. But before you can talk about content, you will need to start with something that the syllabus calls, the Baker factors. Now, let's look at the syllabus. I will want someone to read this part for us. Do you have any volunteer? Anybody?
Yeah, I can read.
Okay,
from where
right.
you want me to read?
Okay, so let's start from, let's read this whole chapter since it's what we've been talking about. Then if anyone has any questions from it, then we'll take it. All right, let's start.
7. So topic number 7 is the content of procedural obligation, right to be heard. We turn now to this question: if procedural obligations are triggered, what does the decision maker have to do? Or more concretely, what is the content of this procedural obligation? If your procedural obligation comes from a statute, the enabling act, or one of the special legislated procedural codes discussed at CB 72 to 78, the answer to this question is whatever the statute says is the content. However, there may be occasions in which you will have to determine whether the statute is a complete code or leaves room for common law supplementation. Life is more complex if your trigger is the common law, charter, or Bill of Rights. While there are some differences, generally speaking, the content where these sources apply boils down to two broad classes of procedural rules: a right to be heard and a right to an unbiased and independent decision maker. Within these two classes, there are many details, and you still need to understand what does it mean in practice to have a right to be heard, and what does it mean in practice to have a right to an unbiased decision maker. The basic issue is this: the precise content of procedural rules coming from the common law, charter, or Bill of Rights varies from case to case according to the circumstances. Certainly, with respect to the right to be heard, you must start with the Baker considerations. Baker gives you a non-exclusive list of consideration that tells you at least something about content. Specifically, the Baker test suggests whether the content will be robust or not. It actually tells you a little bit more if your trigger is legitimate expectations. With legitimate expectation, the content of the procedural obligation is generally what was promised in the procedural promise that gave rise to the legitimate expectation in the first place. If the promise was substantive, you will not be able to enforce it directly, but at the very least, it may lead to enhanced or more procedural fairness.
All right. Yeah, thanks. Thanks with that. I think the rest just basically tells us whether, the concept of whether something is robust or not is not just sufficient. You have to unpack the concept. But based on what we just talked about, remember what we just explained: legitimate expectation cannot be used to generate a substantive outcome. And that is what they are saying here in the syllabus, that with legitimate expectations, the content of the procedural obligation is what was promised in the procedural promise that gave rise to the legitimate expectation in the first place. That if the promise was substantive, you will not be able to enforce it directly, but at the very least, it may lead to enhanced or more procedural fairness, which was what I've been saying for the last few minutes. Now, Baker, so what I wanted to point out from that is that Baker basically just tells us what we need to know about the content. So Baker suggests to us whether the content will be robust or not. So which means the moment you are done with your sources, your triggers, your threshold, before you proceed to the content, you have to what? You have to start with Baker versus Canada, which was the case where the court, laid down the factors that we refer to as the Baker factors. So after you discuss the Baker factors, then you can now move into your content, which can either be the right to be heard and right to an unbiased decision maker, or so this is the way I've divided it. So some notes we call it right to be heard and right to an unbiased decision maker. And under right to be heard, you see things like notice, discovery, delay, and every other thing under it. And right to an unbiased decision maker, you see things like reasons, bias, prejudgment, hearing, overlap of functions, and stuff. But some other notes, so I'm trying to cover the bases here. So some other notes, we divide it into pre-hearing issues, hearing issues, and post-hearing issues. So depending on whichever notes you're using or textbook, it's the same thing. So if it's pre-hearing issue, these are some of the issues that will happen at the pre-hearing stage. If it's a hearing issue, these are some of the issues of participatory rights or content issues that will be applicable at the hearing stage. If it's a post-hearing issue, these are some of the issues. So some notes may have more than what I have here, but the idea is just that you have to start with the Baker considerations first. And what are these Baker considerations? There are 5 factors. The first one is the nature of the decision being made and the process followed. The second one is the nature of the statutory scheme and the terms of the statute pursuant to which the admin body operates. And the third one is the